So today's webinar, and thank you to New Zealand Shores for the opportunity to share with you probably one of the biggest policy changes in recent immigration history. And so we're going to give you today a quick recap of the accredited employer work visa process and the immigration rebalance announcement. We'll cover the job check requirements, and we'll also talk about applying for an accredited employer work visa. And if we have time, we'll answer a few questions from Sarah and Fabian if that works out. So without further ado, again, thank you to New Zealand Shores for inviting us, and we hope that you find this presentation on the new policy interesting, informative, and helpful. So I'll pass it over to you, Carl.
So yeah, look, as probably as most of you would already know, and may well be up with the play to date in any case, the government announced the changes to the immigration system in terms of the way we do things, removing essential skills work visas, long-term skill shortage, and amalgamated them all into one. And basically they flipped everything upside down. So you probably know that previously somebody wanting to make an application for a work visa was all led by the migrant. In this system, it will change to being employer-led. And it's a three-stage process. Already 4,500 people have made an application for accreditation, which opened on the 23rd of May. And a number of those 3,500, I think, have already been approved. So the principle behind this is that the employer, once they become accredited, applies for stage 2, the job check, which takes effect on the 20th of June, and people are already making an application for a job check. And then the third check is the application by the migrant worker themselves. So it's flipping it upside down and basically saying, we will pre-approve the employer for a job rather than the migrant having to provide all the information being supplied by the employer. So the idea of it is that it gives it a lot more certainty for an employer in that you know that if your job check has been approved, then you can go ahead and recruit a migrant worker to that particular job. Next slide. So a little bit about the immigration rebalance, and this was based on the government's thinking that they wanted to improve the increase productivity and also improve in terms of increase higher wages. And as part of immigration rebalancing, and we'll open up the borders again on the 4th of July for the accredited employer work visa, so people offshore will be able to then come in without having to go through the COVID process. And what it will incorporate is, and it's closely linked to the accredited employer work visa, in that employers will be able to hire a migrant worker so long as they're paying above the median wage, taking effect from the 4th of July. So if you're paying above the median wage, you'll be able to use the accredited employer work visa system to recruit migrant workers. There'll be a green list for high-skilled, hard-to-fill occupations, and that will be in 2 parts. So part 1 will be people where the occupation is identified as highly skilled and will be able to go directly to residents. And then there's a second group of people who will work for 2 years before they can apply for residence. And those occupations will be are identified on the green list as hard to fill occupations. And just to make a point here as well, what we're giving you here is really a fairly high level overview of the immigration policy, because there's quite a bit of detail sitting behind the immigration rebalance criteria, and you'll find that on our website. There will be some exemptions to the median wage, and therefore people in the care sector, where obviously we know that there's a big demand for people in that sector, and that in that particular sector, it's very difficult for them to be paying the median wage to their employees. So there have been some exemptions created for people in the care sector, the construction sector, in tourism and hospitality, and they will remain in place until around about the 23rd of April. There'll be sector agreements as well for certain sectors, and those are ongoing in discussions at the moment, and we'll incorporate the ones that I've just made reference to, and include meat processing, seafood, and seasonal snow and tourism operators. Next slide. Employer accreditation, we'll just move on through that. So in terms of the employer accreditation, if you're recruiting migrants, or if you're recruiting less than 5 migrant workers, you can apply for standard accreditation. If you're wanting to recruit more than 5 workers, then you need to apply for high volume accreditation. So just on that point, if you're not sure how many migrant workers you're likely to recruit, and this is over a 6-month time frame, so your planning would be on the basis of over the next 6 months, how many migrant workers am I likely to want to recruit? If you're thinking that you're not sure whether it'll be 4, 5, maybe 6, I'd suggest you just go straight to high volume accreditation. The detail of the two are very, very similar, especially for this first 12 months. And there will be additional information required and additional detail for employers who are franchisees or what we call controlling third parties. You can upgrade to the higher volume accreditation if you choose to, but my suggestion is if you have reservations or doubts about how many you want to go for the high volume accreditation right from the very outset. It then allows you to have a little bit more flexibility. Next slide. So there's some minimum requirements for all employers in terms of that accreditation. You've got to be a viable and genuinely operating business, IRD registered with a New Zealand business number. You have to complete settlement support activities, and that's basically providing information about what's in the region to support those migrants, what kind of, how do you get a bank, how do you open a bank account, how do you get an IRD number, what kind of community facilities are there within the region or, close by. Just basic settlement information that any new migrant wanting to come to New Zealand would want to know about. You must comply with immigration, employment, and business standards. So one of the things that immigration will look at in respect of that is, have you been in breach of immigration visa requirements in the past, or employment law, for example? And, assuming that you haven't and there's no breaches recorded against you, then the accreditation should be relatively straightforward. Pay recruitment costs, you can't on charge those, so any recruitment costs are your cost. And you've got to allow time, and you have to complete as the employer or the senior people within your company need to complete the employer online learning modules, and they're provided, the detail of that's provided on our website. And you must also allow your employees to complete the online learning modules. The reasoning behind that is that, the whole point of this exercise is to try to minimize the risk of migrant exploitation. And the ways that we can do that are to allow employees within the first month to have the opportunity to know and understand their employment rights as a migrant worker. So there's additional requirements for franchisees. They've got to have been operating for at least 12 months as a franchisee, and they must show that at least 15% of their workforce are New Zealanders or residents who have 30 hours of work a week or more. So immigration considers 30 hours a week or more to be full time. Controlling third parties, that's another new area. In terms of what is a controlling third party, a separate legal entity So, and the third party exercises control over the accredited employer work visa holder. And the third party has a contract with an accredited employer that allows the accredited employer work visa holder to perform work for the benefit of the third party. So as an example, you could have, I don't know, just pick a bank. BNZ, for example, might be the accredited employer, so the employment contract is with the BNZ, but the BNZ then wants to transfer the migrant worker to work for another bank or another IT organisation, for example, where that new employer will have direct control over the individual. The third party doesn't necessarily have to be an accredited employer, but they must be a separate legal entity. And given that they have control over the individual while they're working for them, the legal employer, so the direct employer, is the one that takes full responsibility for that individual. So if the third party, for example, breaches immigration visa requirements or immigration law or labour law, then the principal employer will be the one that will carry the responsibility for that. So accreditation periods and renewals, and just in terms of the accreditation itself, it's a pretty straightforward process. It's an online process, and there's not a lot of documents that you're going to need to upload for the first period of accreditation. So we're pretty much taking people on face value. When you complete that online application, we'll take you at face value in terms of what you said you are doing and what you are going to do over the next 12 months. And then obviously at the end of the 12 months, then potentially when you go to renew your application for accreditation, that's when we could potentially ask for evidence of certain things that you indicated you were going to do in your original application. So for franchisees and employers that place migrants with third parties, the renewal will be for a further 12 months only. And for all others, it's a further 24 months. Just a rundown on the fees. So standard accreditation up to 5 migrants, $740, 6 or more, $1,220. If you're on standard accreditation and want to upgrade, $480. Labour hire companies and employers placing migrants with controlling third parties, it's quite expensive, $3,870, but there's quite a lot of risk and verification associated in that regard in terms of ensuring that the workers being placed at the third parties meet certain requirements. Franchisee employers, $1,980, and the reconsideration of a declined application, $240. Now I'm going to pass back to Rob now, who's going to cover off the job check requirements, and then I think I'll come back in later on. Thank you.
Thanks, Carl. So, job check requirements, which is the interesting bit, and job check opened on Monday of this week. So it's very fresh in everybody's mind. So the purpose of the job check is to ensure there are no New Zealanders available to do the job. This aims to support local employment opportunities and ensure that employers are offering attractive wages to New Zealanders before they look to recruit a migrant. The job check will also help to ensure migrants recruited into New Zealand on an accredited employer work visa are mostly filling higher skilled roles. Thank you. So, the pathways through the job check. As we mentioned at the start of the presentation, the green list is not the only way to bring a migrant to New Zealand for work. The other pathways that can be taken are for you to pay at least the medium wage. These jobs must be advertised to check if New Zealanders are available. You could be paying twice the medium wage. Proof of advertising in this scenario is not required for the job check, and a work to residence pathway is available for these roles. Being on the green list, as with paying twice the medium wage, Proof of advertising is not required for the job check for these particular roles, and there are streamlined pathways to residence, either a fast track straight to residence for some roles or a work to residence pathway, which you might have seen in the media recently. A wage exemption, some roles, as Carl has already mentioned, are exempt from paying the median wage, but will need to be advertised to check if New Zealanders are indeed available. So, thank you, Fabian. So, transitional exemptions to the median wage. There are a small number, and it is a small number, of roles that are exempt from paying the median wage, affecting construction, infrastructure, tourism and hospitality, and care. This is just a transitional agreement while sector agreements are concluded. Specific jobs in construction and infrastructure and tourism and hospitality must pay at least $25 an hour. This does not include some key roles such as a cook, where there are concerns that the role is being used to take advantage of the immigration pathways to qualify for residence. Probably really important for you all to note that the exemption to the median wage threshold for tourism and hospitality is only available until April 2023. They'll have to meet the median wage after that date. Specific jobs in the care workforce sector must be paid at least $25.39 an hour. You can visit the INZ website to find out which roles are eligible for these exemptions. An accredited employer work visa paid below the median wage in these cases can hold the accredited employer work visa for 2 years before completing a stand down of 12 consecutive months outside New Zealand, and then they can get another accredited employer work visa for 2 years. Migrants can get another visa for a job paid above the median wage without having to complete the stand down. Hope that all makes sense. So, proof of advertising, which is the key one for all of you, is required for all jobs, except where the remuneration for the proposed employment is $55.52 per hour or above, or the equivalent annual salary, or the proposed employment is for an occupation included on the green list and the minimum requirements for the job, including the requirements on the list for that occupation. This is listed in a thing called Appendix 13 of the Immigration Instructions, so you can certainly find it there. Thank you. So, the big green list. The green list makes it easier for employers to hire and attract migrants for specific high-skilled, hard-to-fill occupations with guaranteed residence pathways for eligible people. The green list covers roles across construction, health, social services, ICT, electronic, telecommunications, engineering, primary industries, science, agriculture, and some trade sectors. These roles will have registration, qualification, or experience requirements. You can find all the details of this stuff in more detail on the New Zealand INZ website. The green list occupations are listed by the Australian and New Zealand Standard Classification of Occupations, or something called ANSCO, and qualifications must be comparable to the New Zealand qualifications listed. Unless an overseas qualification is listed on the INZ list of qualifications exempt from assessment, an international qualification assessment, or something called an IQA from the New Zealand Qualifications Authority, stating the comparable NZQF qualification will be required. Acceptable employment for a job check. We define what is acceptable employment for a job check. It must be full-time work, at least 30 guaranteed hours per week for the duration of the employment period. The remuneration for the proposed employment must be at the market rate for that occupation and at or above the median wage, unless it is for an occupation that is exempt as detailed in Appendix 14. The current median wage right now is $27.76 per hour, or the equivalent salary. The proposed employment agreement needs to include all the mandatory clauses that are required by employment law and must only include clauses that are compliant with employment law. If travel or changing locations is part of the proposed employment, the terms and conditions of that travel or change of location must be set out in the employment agreement and not have the potential to disadvantage the migrant employee. The proposed employment must not be for self-employment or planting, maintaining, harvesting, or packing crops in the horticulture or viticulture industries, and it must be paid at least monthly. An approved job check is not our endorsement that all details of the employment comply with employment law. You should honestly get advice about complying with employment law if you need to. You are responsible for ensuring that you comply. So, Fabian's hurrying me up here and rushing through it. So no worries. So, applying for a job check. Firstly, applications must be made using the online form on the INZ website, and this will be available from last Monday when applications opened for the job check. In terms of what is needed for a job check, employers must include evidence demonstrating that they meet the requirements, including a detailed job description, the proposed employment agreement, and the employment agreement should include all mandatory clauses required by employment law, such as name of the employer, job title, job description, hours of work, duration, type of agreement, whether fixed term or permanent, place of work, details of pay and conditions. It should detail paid leave entitlements, and it should only include clauses that comply with employment law. It should outline details of overtime rates of pay and how that is defined, and it should state the pay period. At the work visa stage, some of these things must be the same, so they need to match up, and some of them can change, but only if more favorable to the applicant. Evidence of advertising the job if it is required, which brings us to the next slide, Fabian. Attempts to recruit New Zealanders by advertising. So the job advert must include minimum qualifications, work experience, skills, and other specifications must be actually necessary to perform the work on offer, and the remuneration must reflect those requirements. Thank you. Attempts to recruit New Zealanders by advertising. The job must have been advertised on a general national job listing website where suitable New Zealand citizens or resident class visa workers are more likely to apply, or by other means if those means are more likely to attract suitable New Zealand citizens or resident workers, for example, on an industry-specific listing website. The job advert must have been listed for at least 14 calendar days, and the advert must be closed prior to the job check application being submitted. The end date of advertising must be within 90 days prior to the job check application being submitted. So then we calculate remuneration. It will be calculated on the basis of guaranteed payment per hour. For employment to be assessed as meeting the minimum pay threshold, the average guaranteed remuneration for each hour of work within the pay period, including any paid leave, must be at or above that threshold. If all or part of the payment is proposed to be by annual salary, the payment per hour for the salary portion would then be calculated by dividing the annual salary by 52 weeks, followed by the number of hours that will be worked each week. If the payment is by salary, but not annual salary, then the relevant number of weeks will be used instead. Where the remuneration is not yet confirmed, but will be within the range, the calculation will be based on the lowest rate. Remuneration may include the value of any reasonable deduction from salary or wages for goods and services like accommodation provided, but the value would be specified in the proposed employment agreement. For the purposes of immigration instructions, remuneration excludes other employment-related deductions or allowances. For example, tool or uniform allowances, piece rates, commissions, or bonuses, which are all dependent on performance and not guaranteed. So, determining the location of the job, another hot topic. For the purposes of these instructions, the location of the job is the place where the work is entirely or principally carried out or based, as per the proposed employment agreement, and the information provided in the job check application. Regions are based on regional council boundaries, and cities are based on council boundaries. If the work is proposed to be carried out or based in more than one location, an immigration officer within Immigration New Zealand may determine that the job is located in multiple locations. An immigration officer may also request further evidence to determine where exactly this job is likely to be located. So, hiring for multiple positions, multiple jobs may be included in the job check application if the following details are the same for all jobs. So this relates to multiple jobs. The proposed occupation, location, same region, minimum guaranteed remuneration and maximum remuneration, and type of agreement, whether it is permanent or fixed term. The minimum qualifications, work experience, skills or other specifications required for that job, the job description, the proposed employment agreement, and if required to advertise the job, all the jobs are included in the same set of advertising. So when a job check is approved, it will be approved for a duration of 6 months. An approved job check will expire after 6 months, or when the employer's accreditation were to lapse, or it is revoked by Immigration New Zealand, whichever occurs first. An approved job check will specify the occupation, the minimum and maximum remuneration for the employment, the location of the employment, the number of jobs approved, the job check start date, and the job check expiry date. If an employer applies for a job check for multiple jobs, an immigration officer may approve the job check for the same or fewer number of jobs requested, depending on whether each job meets those requirements. I will now hand over to my colleague, Carl. I know there's a lot of detail to take in and soak in here, but honestly, the website does go into quite a lot of detail on this stuff. Thanks, Carl.
Thanks, Rob. Right, so the accredited employer work visa. So now we're at the stage where you've gone through, you've done your accreditation, you've completed your job check, and now you're offering a position to an individual migrant worker for a particular role. So now we're at the stage where the migrant is now going to make his or her application for an accredited employer work visa. So they've got to provide evidence of the employment agreement that's been offered. So a lot of this is very much the same as it would be for an essential skills work visa application that most of you will be familiar with. Really, it's kind of looking at it from the perspective of the migrant and saying, well, what does the migrant need to provide in order to support that? It's going to be an online form as well, so that's something new. It was a paper-based application, and now it will be an online form. They need to provide a copy of the employment agreement that's been offered, a copy of a signed offer of employment, and those two can be amalgamated into one so long as the signature and the terms and conditions are the same on the employment agreement. The employment agreement's fine. And a job check number from the accredited employer. So that job check number is basically when we approve, say for example, an employer applies and he has 5 job checks that he's completed, then each of those will be allocated a job check number. That job check number will be given to the migrant so that the migrant worker can quote that reference number when they make their application for the work visa. Because in our system, up against the employer, it will have what job checks have been approved, for who, for what, and for what time frame. And so at that point, that reference number will be given to the migrant and they'll quote that as part of their application. Next slide. So as per normal, they've got to be able to demonstrate they meet the generic work visa requirements. So health and character, are they, is their health to an acceptable standard from an immigration perspective, no character issues. Are they suitably qualified by training and experience to do the job that's offered? So really, this is all a matching exercise. The employer's done the job check. They've provided a whole bunch of information around what the job is, the nature of the job, the duties expected, the qualifications and skills required. So we are now, from an immigration perspective, looking to match that. So if you've offered a migrant worker a role, but it doesn't meet the advertising or the job description, then clearly we're not going to approve that application. So if you said you must have 5 years experience working as, but the person's only got 3 years, then that could become an issue in terms of, well, that's not what was advertised and that doesn't meet the job description. So they've got to prove they hold an offer of employment that meets those requirements, and where the employment is paid below the median wage, the migrant's not subject to a stand-down period. And so that stand-down period is if you're being paid less than $27.76 an hour, and the stand-down period has been in operation for quite some time, but it's also part of this new changes, that you're not, the individual's not subject to a stand down period already when they apply for that particular role that you've advertised. Next one. So determining if the applicant's suitably qualified, an applicant's qualified to do the job if they've got the qualifications, work experience, skills and other specifications listed by the employer. And as we say there, don't forget it's a matching up exercise. So what the employer's advertised for in terms of the skills and qualifications, we want to make sure that the individual you're offering the role to also meets those qualifications and skills specified. Except for with a job for a chef, the applicant must have a New Zealand certificate in cookery level 4 or higher. And it was specifically put in for chefs because it's difficult with chefs. When is a chef a chef? So effectively, they've put a qualification for that on the basis that it's proved to be a fairly risky occupation in terms of the level of skill required for somebody to claim to be a chef. So as a consequence of that, they put a qualification for that to occur. Next slide. So a person may hold an accredited employer work visa below the median wage, and Rob touched on that previously, for a maximum of 2 years before they are subject to a stand down. So basically what that means is, if you're being paid below the median wage in one of those occupations that Rob referred to, then you will be required to, you'll only get a work visa issued for 2 years, and then at the end of that 2 years, you'll be required to either return home for a 12-month stand down before you can come back again, or if you move to a higher position during that 2-year time frame where it's above the median wage, then that won't be necessary. So person below the median wage is not eligible for a further accredited employer work visa, but paid below the median wage until they've spent 12 months outside of New Zealand. Next slide. So the conditions of an accredited employer work visa, normally for most people, it will be a maximum of 3 years if they're paid at or above the median wage, or obviously if the contract that's being offered is for less than 3 years, it'll be in line with the contract that's being offered, or a maximum 2 years if paid below the median wage and subject to a stand down period. An accredited employer work visa holders may only work for a specific occupation, specific employer, location, paid at or above a specific remuneration unless they apply for a variation of conditions. So a lot of this, whilst it sounds complicated and complex, it's really very much the same as what it would have been under an essential skills work visa application. But as I mentioned before, it's kind of tipped it upside down so that the employer is pre-approved for a particular occupation, which is a significant advantage. Next slide. So green list occupations. So there's two groups. One is a 2-year work to residence, or the other group is fast track straight to residence. And the details of those occupations are on our website. So if you go and type in the web link there below, you'll find what those green list occupations are and which ones qualified to go straight to residence and which ones require a 2-year work visa. And of course, paid twice the median wage, 2-year work to residence if you're paid, twice the median wage. And in terms of skilled migrant category, that's still being looked at by government in terms of what they want to do with that. Do they want to make any tweaks to the skilled migrant category? And further decisions on that will be coming later on this year. But that will be another option for people to apply for residence if they don't qualify under one of these other, under the green list occupations. And that's about it from us. And look, as Rob said, and as I mentioned earlier, we've tried to keep this fairly high level on the basis that the detail is quite detailed, and you're best just to go to our website. Everything you need to know is in there. Well, everything that we need to know at this point. As we all know, things are quite often subject to amendments or changes, and without the skilled migrant category as another residence pathway, we don't have any information on that at this point. So thank you. I guess we'll go to Q&As.
Yep. Awesome. Thank you, Carl. Thank you, Rob. That was very informative. Thank you. We have had some good questions come through, so we'll read a few of those out. Perhaps we'll direct them at you first, if that's okay. Can I just see them, Damien? Yeah. Apologies. Okay, so first one, does it cost $610 to get a job check per role? Do we have to apply for a job check for every role we want to employ migrants for?
That's a good question, and one that wasn't actually covered off. So in terms of job checks, if the role that you're advertising, you need, say, 5 people in one particular role. So they might be software engineers. One role, same details, same job description, within the same salary range, it's one job check. If it changes, then it's a separate job check for each occupation. So if you're looking for 5 software engineers, one job check, one fee.
Noted.
Okay, so just moving on to that, if you're looking for 5 software engineers throughout New Zealand, say different branches of the same company, and they're all they will all meet the green list requirements, being paid $120,000 a year. Considering there are various locations for these high-level positions, can you still all include them in the same job check?
You could, so long as you made it very clear in that job check that the role and the employment contract and the advertising indicated that. Because basically what we want to know from an immigration perspective is if people are going to move around, that the migrant knows that potentially they're going to need to move from one place to another, and that you have advertised the role outlining that detail in terms of the multiple locations. So it can be considered on that basis, especially where it's on the green list.
Okay, thanks, Carl. Just another one. I'll ask this one, Fabian. Someone said, does this mean all current visa holders within the hospitality industry must be on $25 per hour? This obviously only relates to the accredited employer work visa at the moment, doesn't it? So if employing someone on a working holiday visa, open work visa, does not currently.
Correct.
That is correct. Yep, doesn't affect current visa holders. As long as your visa is valid, it doesn't cover that.
Okay. Should we go through these, Fabian? So the way that the variation of conditions currently works for essential skills work visa, do you foresee that being the same under the accredited employer work visa, or if someone wants to change across to a different employer, staying in the same role, let's say electrician, staying in the same region, let's say Auckland?
Operational policy are working through the variation of conditions that work within the AEWV policy right now.
Okay. Yeah, thanks, Rob. Next one.
Great. Another one regarding determining the qualification or work experience requirements. The new policy states that this will be determined at job check level rather than the visa level. Is that correct? And is a case officer strictly going to refer to the requirements listed under ENSCO, or is there any flexibility there?
ENSCO now becomes a guide. It's not the definitive decision making. It's a guide.
Okay, awesome.
So quite a change.
Yeah. Okay. So just to recap, can I pay a migrant below the median wage, which is?
Yes, you can, but only for occupations listed in Appendix 14, in line with the hourly rate threshold for those occupations, i.e. construction and infrastructure roles can be paid $25 an hour.
Yeah. So if not on Appendix 14, the answer to that is no.
No.
Must be at median wage or above.
Okay. We have seen a bit of confusion between the job check and the labor market test for the advertising. The job check is a completely new requirement for employers. It's essentially an extra step. And because labor market test or advertising is not required for certain occupations on the green list or for highly paid positions, some employers are questioning why they need to do a job check at all. What's the reasoning behind this? Because there is a substantial fee associated with the job check.
Well, the whole idea is that we still must ensure that there is no New Zealander or resident of New Zealand available to do the job. That's why.
But just to add to that as well, it's about saying, well, what is the job that you're going to be offering that migrant worker? Because otherwise we don't know, do we? So unless the employer does the job check, we don't know what the detail and what that job actually is. So in order for the migrant to apply for that role, we need to know that it meets the requirements of the job check, even though the occupation's on the green list.
Yeah, okay. So just to confirm, if the job is on the green list or paid twice the median wage, a job check still needs to be submitted, but advertising is going to be waived.
Absolutely.
Correct.
Bang on.
Yeah, awesome.
Yep. We have had information from Immigration New Zealand that, and I'm moving forward a bit there, but from 2023, employers will need to be accredited even to hire people with open work rights, such as working holiday visa holders or post-study work visa holders. Is that going to impact the employer's quota as well for those with a cap?
Yeah, we really don't know the answer to that at this stage. I wouldn't want to, you know, pretend to answer it without fully realising there'll be more on that coming. Obviously before April 2023. All we know at the moment is, yes, they'll have to be accredited, but the detail around what happens to those people on open work visas and, you know, is there a job check required, etc., is highly unlikely. But we need to wait for information to come out from that from our policy people.
Thank you.
Okay, just one more from me. In terms of someone offered a salary, in terms of their employment agreement, how can an employer guarantee that an hourly rate is met if no overtime is paid based on the contract?
Right, so what we'll be looking at is the employment contract, and you're going to have to be very careful around the hours of work and the rate of pay, because, you know, you hear, I mean, we get it here. Employers say, well, you're paid a salary, so it swings and roundabouts. You know, you might do 45 hours one week or 60 hours one week and 20 the next. It doesn't operate that way from, you know, a migrant perspective. We want to ensure that people aren't being exploited. And one way to ensure that is that the hours of work clause and the pay per hour is clearly identified. So all hours worked, so you might have a clause that says the hours of work shall be 40 per week, paid at an hourly rate, which might equate to a salary, an hourly rate of $45 an hour. All time worked in excess of 40 hours shall be paid for at $45 an hour or an overtime rate. So it's just to be very explicit in the employment contract, because the whole point behind this is to try to minimise migrant exploitation by making people work long hours on the basis while you're paid a salary.
Thank you, Carl. So in other words, looking at this from a different angle, if the employer is not willing to pay for overtime, then the maximum number of hours must be specifically stated on the employment agreement, and the case officer, when assessing the work visa, would assess based on those maximum hours.
Yep, exactly.
Yep. Just one other that popped up. So the job check is approved or valid, shall we say, for 6 months. Does that mean the migrant worker would have to lodge their accredited employer work visa within that 6 months, or it must be approved within that 6 months time frame? Do you know when that 6 months expires?
So it would be when they lodge it.
Lodged.
So long as the application's been lodged, because at the end of the day, you know, it could be our fault from an immigration perspective that we're just not able to get onto it within that 6 month time frame. So once it's lodged, it's fine.
Okay, noted.
Okay, another question that popped on the Q&A, a little confusion about who actually must take the new employment modules. Is that all the key persons as listed in the accreditation, or only people involved with recruitment decisions?
Yeah, we've had that one been bouncing around quite a lot. So it's basically those that are involved in the decision making to hire the migrant. So we've kind of got down to people like the head of HR and maybe the chief executive or you know, general manager. Those that are involved in the decision making process. So if you had a panel, for example, made up of 2 or 3 members of the team, but those people are not actually making the decision, then they wouldn't be required to do the employment modules. We encourage, you know, as many people as possible to do them, because it clearly gives you an understanding of employment law, etc. But generally speaking, you'd be talking about the HR manager and the, you know, senior executive.
Thanks, Carl. Last question. So someone that's currently on an essential skills work visa, let's say they've still got 2 years on that visa, but they want to do a variation of conditions. Will the new employer then need to be accredited, or will they grandparent essentially essential skills work visa policy for VOCs?
No, so sorry, can you just rephrase, repeat that?
So current essential skills work visa holder,
yep,
but has a new job, wants to apply for a variation of conditions, but remain on the essential skills work visa. Would the new employer need to be accredited in order to get it? Does that make sense? So
Yeah, so I mean, no, because it's only going to apply.
The accredited employer work visa.
Correct, yeah. So everybody that's on the existing visa is kind of like grandparented until they run out. But then when the employer so say somebody's got work on an essential skills work visa currently, and it's got 6 months left to run, the employer doesn't need to become either accredited or require a job check until that work visa is about to expire and they decide that they want to try and keep that person. But they've still got to go through the job check process in order to re-employ that particular individual, and therefore prove that can't find New Zealand permanent resident citizens still to fill that position. So therefore, we want to retain the services of the individual we've already got.